The Air Force Research Laboratory provides unflagging support for the United States Air Force and its mission to fly, fight, and win.
Good afternoon, everybody, and welcome to the AFRL New Mexico Tech Engagement Office's webinar on intellectual property. This is week 4, so we'll be talking about engaging with our office and figuring out next steps for how you pursue getting a patent. My name is Matt O'Brien. I'm the program manager with the Tech Engagement Office. On the call as well, we have Anna Kutula, who's our IP lead. She's also a patent agent. We have David Narciso, who's a patent attorney with AFMC at Wright-Patterson Air Force Base. And our guest speaker for this series, Dr. Gary DeBoer, who is a visiting summer faculty fellow from LaTourneau University. And he'll be starting our presentation today. Go ahead and take it away, Gary.
Hi, thank you, Matthew. So just to recap where we were in the last few weeks, we've discussed a little bit about why we would want to patent and what is patentable. And last week we talked about the application process. So today we want to get into some real applicable stuff with respect to how you as an inventor can engage with the Tech Engagement Office. And the engagement process involves making first contact. And that first contact involves the invention disclosure form and the invention evaluation form. So when you contact the Tech Engagement Office, these are 2 forms that you're going to be filling out. And that's going to be the start of the whole process here as we go forth. So here we have our first survey question to see if anybody is with us. And if Noah is there and can launch our survey.
Yep, about to launch it now.
So the question is, if you have an invention, who do you contact? InventHelp.com, Starfleet, the U.S. Patent and Trademark Office, U.S. Department of Commerce, or the IP lead at your local AFRL Technology Transfer Engagement Office. Well, I think the answer here is pretty clear that you want to contact the IP lead at your local AFRL Technology Transfer Office. Did we get any other answers to that, Noah?
We did get 1 vote in for the IP lead at your local AFRL Technology Transfer / Engagement Office, but that was the only vote for that.
Oh, okay. And who is that person? Well, that's Anna, and she'll be talking to us a little bit later. And you can contact her at her afrlnewmexico.com or her us.af.mil email address, or by phone there at 505-846-1897. And this is important because in the Air Force regulations, if you read them, with respect to things that are inventions that might be patentable, it says that Air Force personnel will refrain from publicly disclosing. And if you've been with us on previous webinars through the summer, you know why that disclosure thing is a big issue. Because if you disclose before you file for your patent, it may bar you from obtaining a patent on that invention. Another part of the regulations here is that the Air Force personnel will report all inventions made while employed with the Air Force. So not only must you not publicly disclose, you must disclose your inventions to the Tech Engagement Office here if you're employed with the Air Force. And so we'll be talking about this today using these 2 forms, the disclosure, the invention disclosure form, and the invention evaluation form. And at this point, David was going to talk to us about these forms. Is David with us?
I am. Can you hear me at all?
I can hear you. Great. Good to hear you.
Okay, great. Okay. the slides weren't able to make it to you. Is there a way I can take over the desk top and share them from here?
Yeah, David, Noah should allow you to be able to do that. Let me stop sharing.
I just promoted you. You can share your screen now.
Okay, I stop sharing.
Okay. Let's see, where do I do the share screen?
There should be a share screen at the bottom of your Zoom webinar, a green up sort of arrow thing.
Okay, let me get which screen I want to share to make sure it's working right. Okay.
Hey, looks like you got something there.
Okay. Now we just want to show the whole slides. Where is it? Okay, well, you see the basic slide of the invention disclosure form, which you mentioned earlier. And you know, it's not a test when you fill it out. It's just a vehicle to give us the information we need, and is not the end all. We'll go through this a bit, in that you can attach other documents to make sure that we understand what the point of novelty is and publications you're aware of. So the form basically has some basic parts. The initial part to give us the standard information. So just a very descriptive title, as best you can come up with. And then a general description of what the invention is with relation to the existing art. So kind of a short paragraph or synopsis of what is believed to be novel. There is not a requirement to do any kind of a prior art search, but if you know something about it, that's helpful. And you don't have to know how inventive it is or what the value is of it. The critical thing for the inventor is this something different than what was done in the past, and that's a very low bar for the disclosure. We can evaluate things further based on the information provided. The next section is to name the inventors, and as has previously been discussed, an inventor is not the same as an author with respect to a copyright. And the question is, who conceived, who thought of what is going to be claimed? The concept would be to err on the idea of including everybody that could have conceived, and then the patent council will work through that once the claims are drafted and figured out according to the law. But we need a lot of information for filling out the forms that are ultimately needed, and to understand who there's responsibility to for the assignments that may be involved. And notice there's a question about whether you're a government employee, and if you are, do you assign it to the Air Force, and if not, then there's a different form we'll discuss. There's a number of specific questions, and these are important for the review to make sure that there may not be an issue with the bar date, where the patent would be unable to be obtained because of a public disclosure. So the question is asked in a variety of ways. Was it in a presentation outside of the organization? And then if the answer is yes to any of these questions and the dates are of concern, the patent attorney will contact you to better understand the context of that disclosure, because it may or may not be a bar. The publications are very important, if there's any publications, and whether it was just disclosed to someone outside of the organization. And then the questions of whether it's sold or whether it's tested or in use. And again, these are not necessarily dispositive of patentability, but if the answer is yes to any of those, we need to investigate that a little further. There's a request to list any publications. And again, you don't have to do any kind of a search, but if you are aware of publications, according to the rules with the U.S. Patent Office, we need to be able to disclose those to the Patent Office so they're aware. And if we don't disclose those, that could lead to real problems. Okay, so it's a short list. And then section 6, here it is a description of what we need, and this would be in an attachment. You'd have to essentially write a document that would address these questions and these issues. You know, what's the purpose? What problem does it solve? So we need to have some background of the invention and the solutions, and then a very good description as best you can of what your solution was, what that invention is. And then are there alternatives? So these are questions that are important when we ultimately draft a patent application too. Now there's a separate form, 1981, and that's an invention evaluation form. And this helps the patent counsel and the reviewers to understand the invention in the context and in order to make a decision on whether to file a patent application. So there's essentially 2 pages. Let's see here. And you can basically, something happened with this. I'm sorry, I don't have the picture there, but you can start the invention disclosure with a lot of information you've already put together for the disclosure form on 1279, Form 1279. The contract number is important because if there are contracts with other corporations or individuals, other entities that are involved in the invention, that affects the patent rights, and we'll need to sort through that. And let's see here. This is this first 5 sections of form. We'll get into this. So the section, you can basically lift from your initial description of the invention on 1279, but with an emphasis on how it relates to the prior art. So, you know, your title and all of that, but here's where we need to know whether there was a contractor involved or a creative partner and what that contract is, because that's very important for determining rights and ensuring we comply with the contracts. So we need to have this other information evaluated. So I don't know if the employee will be directly working in the office to make the security classification and determine if it is or is not classified, or whether if it's not classified, would it still be advantageous to not have it published for national security reasons? And that would become an ITAR issue. So we need to make sure that the appropriate office reviews it for security classification issues and ITAR issues. And then we need to understand, you know, what step are we at with the invention process? Or we just thought of it, is it actually being made? You know, where are we? And then we get to the recommendation. Oh, excuse me. Yeah, then we have other information we need to get with respect to funds and commercial uses. Again, these are relevant for both patentability and for the decision in whether or not to file a patent application. And again, work with the ORTA, work with your coordinator there to get answers to those questions as need be. I think Anna can address some of that a little further. Ultimately, a decision needs to be made. So an evaluator who is someone, it doesn't have to be necessarily a supervisor, but someone that is appropriate and not one of the inventors, needs to evaluate it and provide their recommendation, and then the approving official. Let's see, I think. So the evaluator is someone not on Form 1279, but with enough knowledge to know whether it's something worth going forward with, and then the approving official should be the lab branch chief or above. Here we talked about AFIT, but there it would be the appropriate individual, whether it's at Kirtland or one of the other bases that Kirtland is responsible for some of this information processing. And it can all be signed digitally. Okay. Now, and also note, the inventors don't sign the Form 1281. You'll kind of get it started, but ultimately the evaluator and the approving official can sign it digitally. Now, there's a different form, 1281, which is a 3-page form. I wasn't able to get a copy here. But if the inventor believes the invention was outside of their job obligations, and that they don't feel that it's necessarily the Air Force's property, they can elect to retain rights. But if they do, if you go back up into the Form 1279, in the initial part, if they've checked no on this page here, where they agree to voluntarily grant to the government all their right, title, and interest to the invention, if they say no, then they need to fill out that Form 1280 to explain why, to basically show that it was not part of their job duties. They didn't use facilities or equipment or resources of the U.S. government in producing that invention and conceiving of that invention. And if they can, and I think we had one recent case where someone has filed a disclosure, and so they've gone through the process, but they marked no, and they actually filled out the 1280, and it looks like it's they provided ample justification that it was outside of the scope of their work, and they didn't use any resources of the U.S. government, and therefore they can retain rights. Now, whether you want to do that or not might be questionable, because there are a lot of advantages in my personal opinion, but with things that are assigned to the government, if the government decides to procure the patent and go through the processes. But it is an option. It's just that it has to be well documented that it is not something that the government would own rights in. Okay, so There's a couple of websites that the patent law section here at Right Pat has put together that provide a lot of information and make it available in training type items. And then there's these forms and others available at these links, which are available only with the CAC. Okay, so I need to stop sharing and let you get back to it.
Okay, let me try to reshare here. Okay, so thank you, David. That was good. That was helpful, and I'm sure you'll be talking to the inventors as you go through the process. And speaking of the process, here again is that flow chart of sort of how the patent prosecution process goes from a law firm perspective. And note this might take a while. Might take a while to hear back from the USPTO after you initial file your application. So if you don't hear anything from your attorney for a year or something like that, don't be surprised, because it can take a while to hear back from the examiner. So usually once you get that first office action, things start going at a reasonable pace there, and hopefully you get an issue. Now, David was saying that you can opt out of the system if you came up with this invention all on your own and didn't use Air Force resources. And he was saying, I don't know why you would want to do that. And I would like to, reinforce that as sort of an outsider here, coming from academics, looking in at the Air Force Research Lab and seeing what the Tech Engagement Office and the Air Force Research Lab does for inventors. I would really encourage you to take advantage of the benefits you have in the Air Force. So for example, the Air Force pays for a lot of stuff. They pay for a novelty assessment, a market research. They pay for the patent prosecution, which might cost you $10,000 to $20,000 if you try to do it by yourself. They'll pay the issue fees and the maintenance fees on your patent once it's issued. And not only do they help you with the patent prosecution, but they have ways to help you win the patent issues. The Air Force has connections to get your technology out there, both passive connections on Flintbox, where your stuff is advertised and people might see it and come to you. And they also reach out to companies on your behalf. And you have the AFRL name recognition, which, someone who's looking at technology will say, hey, this comes from the Air Force, it must be good. And I think that's a great benefit. And the Air Force pays you a % of royalties, and they even offer you a sabbatical opportunity if you want to take your technology and develop it someplace else. And to tell you more about how to take advantage of all these things, we have with us Anna. And Anna now is going to talk to us about commercial applications of inventions. Take it away, Anna.
Thanks, Gary. Before we switch gears, just real quick, I saw we had a couple questions on the invention disclosure forms. I don't know if we want to answer those first or wait until the end for those.
I'd be happy to answer any questions now. I'm sorry, I didn't see the questions come up.
I think they kind of were trickling through as you were talking, David. So it's just a couple of questions on invention disclosures.
Okay. Is there a way to recover those?
Noah, could you help us out with the questions on the invention disclosures?
Yeah, I can go ahead and read them to you if you want.
Sure,
Okay.
that'd be great.
Okay, so the first one that came in, they're all from Stanley, by the way. So the first one that came in from Stanley was, what issue of disclosure to team members outside of org?
Oh, what is the issue of disclosure to team members outside of the organization?
Yeah, I believe so. That's what he's trying to say.
Okay, so when it's talking about outside of the organization, the concern would be, what would that be a publication type event? In that there's a one year time bar if the information has been in the public domain, which it can become asserted to have been in the public domain in a number of ways. Now, if it's outside the organization but still within the U.S. government, I don't know if anyone's taken the training that we're all supposed to be taking right now, but I think that's trying to make clear that we have obligations to protect information, whether it's classified or not, that we only have available to based on our employment with the U.S. government. So, with respect to, let me come down to the question here. Outside of your organization, I think that's particularly aimed at outside of the government. But because within your organization, I think you should pretty well know that they're all part of the U.S. government employees. So if it's outside of that, then we would want to delve into it a little further. Again, it's not dispositive, but it's something we need to understand, because the other party may be under proprietary obligations, and therefore it would not be a publication event that would become a barring event. So we just need to understand that and put it into context. It's hard for the individual to make that call. It's better to consult with the attorney. And so we just need the simple answer, yes or no, and when, and then we'll go from there. Hopefully that answers it, but if not, please expand.
Stanley had a couple corrections while you're answering that. So he said disclosure not in publication and only in internal team discussions is what he was talking about exactly, I think.
Oh yeah, that's fine. Yeah.
And then he was talking about his team too. He said his team consists of MIL, CIV, CTR, student, and university professor.
Okay, so now he's looking at a team that includes a university professor. If that's part of
those university professors, they'll be trouble.
Yeah. So, well, if they're a university professor, they should have signed a proprietary form that basically says anything they have access to as part of their work is proprietary to the U.S. government and not to be divulged. So university professors have an obligation to protect anything that they're exposed to. That just because they see it doesn't mean that they're free to talk about it anywhere else. So the university professors should be, if they're part of the team, the only way they could be part of the team is with the contractual obligation. And I don't know if Anna's involved in that. I don't know what the particulars are of the things there, but they should have proprietary obligations.
Okay. Any other questions, Noah?
Yeah, so Stanley had another question asking how to answer GVT funding queue if only pay salary. And he added a little information saying no lab work performed and no prototypes built yet.
I'm not sure if is that. Let's see. Where are we talking about?
I think he's referring to the amount of funding that goes into each invention. So how do you figure out that? Is it based on salary or time or that type of thing?
Oh, okay. I honestly don't know the answer to that. I think it's kind of a ROM question. I mean, whether there's dedicated funds to it or so. This has the government expended resources, including funds, time, and government equipment, in-house or on contract to research and development. Yes, estimate the amount. So it's a guess. It's your best guess as to or best estimate as to what kind of expenditures have been put towards the effort.
Okay.
It's not something that we're going to audit or anything.
So Stanley had one last question for you. He said, if you check no to voluntary grant to government patent rights, does this mean that government will not pay for patent attorney and patent filing?
Okay, so if that's coming back up here, I believe to this question here about whether they agree to voluntarily grant. Yeah, if they say no, what the next step is, they have to fill out this form 1280, and then that form 1280 will be evaluated by the patent attorneys and management to make sure that it's correct, because they may owe the obligation. They may be incorrect. If it's verified that no, the government doesn't have any rights to the invention, yeah, the patent office or the Air Force is not going to pay for patent attorneys to draft the application. The person is on their own, and they can do what they want with it, whether they want to keep it a trade secret and make the item, or whether they want to pursue their own patent application. But the government won't pursue any protection at that point. But marking no is just the first step. So I've seen it both ways. Like I said, just very recently, one came through. They marked no. Everything looks in order. So we'll record that there's an invention disclosure and we don't have any rights, and we'll verify that. We'll finalize that determination. But there are other instances I've seen where I think because they didn't understand their obligations, they marked no, but in fact they had actually developed it under their Air Force employment. So they have an obligation to assign. They might not be voluntarily, but they did at one point volunteer, because as part of employment, that's part of the employment, is that any of the inventions you come up with under your employment are going to be assigned, and that's common to all employers, where they will have an agreement to assign anything invented during employment to the employer.
Okay, thank you for those answers. That is all of Stanley's questions for now.
Right.
Okay, I'm happy to answer any more if he's got them.
Yep, feel free, Stanley, or anybody else to ask any more questions at any time throughout the webinar as it goes on.
Okay. All right, well, we're back to Anna here, and she's going to tell you about all the advantages of saying yes to the Air Force and not going on your own. So
Yes,
take it away,
exactly.
Anna.
Thank you, Gary. So first, I kind of want to touch on what David was talking about earlier with the invention disclosure forms, and that section where you determine the commercial applications of your inventions. So I really just want to get you kind of thinking in a broader sense of what the different applications could be of your inventions. So one thing to look at could be the key advantages of your invention over the current state of the art. Is it lighter, faster, cheaper, better, more efficient? What is it, and how would those unique advantages be applicable to different things? Really try and think about that. Another question to ask could be, what else could your invention be used for besides the purpose for which it was designed? So let's say you come up with a thermal management technology for a spacecraft. Could that be applied to industrial purposes or to, other types of thermal management applications? Really try and think, could it be modified for that purpose without changing the scope of your invention? And then lastly, preempting the questions that licensees potentially will ask. So what is the TRL level of the invention? Is it pretty early stage? Is there room for improvement or changes to the invention? Or is it pretty far along to where, it's pretty set in stone to what it is and how it works? How much would it cost to make or produce? So would this be a substantial cost for a potential licensee to take on, or be a lower cost? Would it reduce some of the costs that they're currently incurring? What would be the difficulty of implementing into existing systems? Would this be something that, potential industry partners could just implement into their systems and not have to revamp everything that they're doing? And then lastly, could it be used for a specific purpose? So let's say, for example, you have a company who wants to license the technology and they have a specific application in mind. Just try and think about in advance, which companies potentially would want to license your technology and what purposes they would want to use it for. So Gary, if you go to the next slide, please. So one other function that our office can provide you, and this can be at any time, it doesn't just have to be for an invention, it can be for any purpose that you need. We can prepare market reports in a specific technology area. So if you have a new idea for an invention, or you're just looking to see kind of the current state of the art in an area you're doing research in, we can pull market reports from very current sources. So we have access to a lot of different databases, such as Frost & Sullivan, PubMed, and these are very reputable databases. And these can be requested anytime. Just let our office know, and we're happy to prepare these for you. Next slide, please. So one thing that our office does after we receive your disclosure and after either a provisional or non-provisional patent application has been filed on it, that's very critical. You don't want to do anything until IP has been filed on it, is we draft what's called non-confidential summaries. So these are essentially one-page documents that include 4 sections. So the background, the purpose of the invention, so what the invention does and what it is, the key advantages, and the market applications. And we like to include non-confidential images if you have them. So if you have any figures, graphics, images that you'd be willing to share with us, they're very helpful for marketing purposes as they have a visual component. So we'll send these summaries to you once we've drafted them for review. And if you have any changes, if we didn't quite grasp, what the core purpose of the invention was, we can modify that. And once it's approved by all the inventors, we post it to a public platform called Flintbox. So Flintbox is a public marketplace for technologies that are available for licensing from universities and government laboratories. So you can see on the right there, the screenshot is what the Air Force Research Laboratory's Flintbox page looks like. And this is only for RD and RV, but it includes all of the technologies that are available for licensing. They have patent applications or issued patents on the technologies. So next slide, please. So essentially, once we've posted the non-confidential summary, what we do is we start a targeted marketing campaign on. So we do this in a variety of different ways, and if you're interested in kind of the details, I'm happy to talk offline about that. But essentially, if we do get responses on our campaigns from companies, we set up a call or a meeting with them. And we'd like to welcome the inventors in these meetings, as they're very helpful to have there to answer any technical questions. And if you do have any publications or other documents that are non-confidential that the company representative can review, that's very helpful to have in advance as well. And if the company is interested after the initial call, our office will talk about potential agreement options with the company representative separately. So the most common thing that we suggest is a patent license agreement, because this is the most straightforward method of tech transfer. So it involves just licensing the technology to a company to, be for use for a specific purpose or to be improved in a certain way, back royalties to the inventors. We also may suggest a cooperative research and development agreement, a CRADA, if it makes sense, if there's a joint research objective that lies within there. Or there's other options as well, but those 2 are the most common. Next slide, Gary, please. So the next steps after that, if we do get interest, essentially our office will handle all of the agreement facilitation. We'll reach out to you to, review and sign certain documents, but once the agreement is complete, we'll let you know. We'll take care of everything on the back end. And if royalty distribution is included, so if it is a patent license agreement, our office will distribute the funds to you as the inventors as we receive them. So we'll keep you very informed on that process. So another way that we like to market our technologies is through what's called technology presentations. So this is not as common as our traditional technology marketing that we do for each invention that we get, but this is if, you know, a local entrepreneur or venture capitalist or a company representative is interested in seeing our IP portfolio as a whole. So if they have a specific, you know, technology area that they're interested in, or areas, we would handpick technologies, usually between 5 and 10, maybe more than that if it makes sense, that fit their interests and present kind of a high-level description of the technology. So if you go to the next slide, Gary. This is an example here of the format of the one slide that we present, and it encompasses those same 4 sections that we had before: the background, the purpose of the invention, the key advantages, and the market applications. And, you know, this really just provides a high-level summary of the technology for somebody to look at and quickly gauge whether they have interest in pursuing it. And if they do have interest, we will definitely at that point, you know, connect in with the inventors and potentially start the agreement discussion process. Next slide, Gary, please. So even if you don't have, you know, an disclosure or a patent application, there are a number of ways that we can still help you in your program. So the first way is through program showcases. So if you have a specific technology that you're working on or a partnership that you'd like to highlight, we can do essentially a showcase around that program and promote opportunities for collaboration. So an example of this is one that we jointly did with the University of New Mexico in February of 2019, I believe. It was centered around the Agile Manufacturing Laboratory and the work that was being done in there. The second way that we can promote your invention, if you have one, is the Innovate New Mexico Technology Showcase. This is a collaboration between the 3 research universities and the 3 government labs here in New Mexico. And each of them pick 1 or 2 presenters from their institution and to present their technology at a very high level. So it's a 10 to 15 minute presentation, and there's businesses, entrepreneurs, other researchers, venture capitalists in attendance at this event. So it's a really good way to get your idea out there and to get some, you know, publicity for your invention if you're looking for licensees or partners. The third program that we offer is the Entrepreneurial Opportunities Program. So this is if you have an invention or idea for a technology-based business that's in your area of research. So you can take up to a 12-month sabbatical from your time at the labs. During that time, you still get your government salary and your benefits, but this has to be approved by your supervisor and it has to be in your same area of research. It's open to government civilian employees. And during this 12-month period, if you're interested, you can do kind of early stage market discovery activities. So, you know, idea validation, you know, market confirmation, things like that. It's really early stage just to figure out if your idea is viable. And at the end of that 12-month period, if you do want to, you know, continue on with the government, if you decided, okay, the business route isn't for me, you can just come back and, you know, nothing has changed. You still have your same position. But if you do want to separate, you can do that as well. You won't receive your salary or benefits anymore. But let's say, you know, you want to come back after 3 years. You still have priority consideration to return to the labs within 5 years after leaving. So it's a pretty good program if you're interested in kind of just that early stage of exploring, you know, your business idea. Next slide, Gary, please. And that's it for me. I'll hand it back to you, Gary.
Okay. Well, you've now reached your destination there. We've talked about a number of things over this summer road trip. We started asking the question, why would you want to patent? What kind of things can you patent? We've looked a little bit at the application process. And now you've heard from David and Anna, who you will be engaging with in the Tech Transfer Office with respect to pushing forth your idea, disclosing your invention, getting it patented, licensed, and marketed, and all of those wonderful things that can happen for you since you work for the Air Force Research Lab. And so now is the time, if you have questions for any of us, to ask those questions. And Noah, do we have any more questions that came in through questions and answers?
Yes, we had one question come in for Anna during her presentation. Oh, actually, yeah, I just had another one from Stan. Is AFRL/RD still engaged with UNM STC?
So yeah, that's a good question. I can answer that. We are still engaged with them. So through the partnership intermediary agreement that our office, AFRL RDMX, has with New Mexico Tech, we've had this agreement for about 25 years now. It's been quite a while. STC UNM is a sub-partner through that. So they actually are, the ones that help out a lot with our technology marketing and commercialization process. So yes, we do work very closely with them. So.
Okay, thank you. And then Stan had another. It wasn't really a question, just kind of like more of a request. He was just asking you, Anna, if you can call him after this meeting.
Okay, will do, Stan.
That's it for the questions for right now. If anybody else has any questions, now's the time to bring them up.
Yeah, while those questions are coming in, again, I would just like to, say to all the AFRL people out there, and also to the summer scholars, they're also included in this. If you're a summer scholar and you're working in an AFRL lab, and you get the name of your primary investigator on this as well, you can also file for a patent through the Air Force. And that would be a great thing for a young person who's trying to build their career to get a patent that way. So I would certainly encourage all of you guys to take advantage of what the Air Force offers you there, because looking at it from an outsider, hey, they offer you a lot of good stuff, and it's good to take advantage of things wherever you are. And if you're at the AFRL, I would certainly take advantage of what David can do for you with respect to prosecuting that application to a patent, and what Anna and Matt can do for you with respect to getting that technology marketed out there and sold and all that good stuff. Any questions come in, Noah?
Yes, but no at the same time. So Stan had he sent in some other questions, but they weren't quite questions. It was just him saying thank you guys for the meeting. It is very informative presentation, and that he appreciates it.
Well, if there's no more questions, I'd like to thank Dr. Gary DeBoer for his work on this webinar. Gary did a really great job. I'd like to thank David for your participation in the webinar as well. Thank you for being around and available to answer these questions and help our scientists and engineers. And thank you, Anna, as well, for your participation today. All of the presentations will be available to our workforce, and I will follow up with an email with all of the links to the presentations. If you have any questions, please don't hesitate to contact me or Anna or anyone else on the call directly. And thank you for your participation.